Good morning, afternoon, evening, wherever you are around the world. I would like to share my presentation.
Что делать? Так.
Are you watching my presentation?
Да, все отлично. It's okay.
Спасибо. Dear colleagues, assistants to the roundtable, I want to thank my dear friend, Dr. Alexander Petrovich, for this wonderful invitation to participate in this interesting legal debate, and also the Vladivostok State University of Economics and Service, the Ural State Law University for host this magnificent event. My topic for today, International Commercial Arbitration in the Asia Pacific region in digital era, a view from Colombia. Suddenly, some of you are wondering why a Colombian lawyer is going to speak about the Asia Pacific region. Well, the first answer I could give you is that the increased cases on international commercial arbitration and the legal framework evolution of jurisdictions such as Hong Kong SAR or Singapore, among others, are impressive. The second reason is because I had the great opportunity, as say my colleague Alexander Petrovich, to do my master's studies in corporate law at Far Eastern Federal University in Vladivostok. And the topic of my dissertation thesis was International Commercial Arbitration, Hong Kong SAR, Singapore, and Colombia. And I'm very glad to share with you some of my reflections about my comparative research. Well, this alternative dispute resolution mechanism is currently relevant as more and more commercial contracts include an arbitration clause as the requirement to sign it. Over the past 10 years, the use of international commercial arbitration has increased by more than 400%. Multinational companies prefer this mechanism to resolve their disputes because of their flexibility, confidentiality, economy, specialization, and impartiality. But I'm not going to refer to the benefits that I have called traditional benefits of arbitration as those mentioned. I will then refer to the central theme of our roundtable, the digital contribution in different spheres of law. In my case, international commercial arbitration, and this contribution I have called it virtual hearings. So what is a virtual hearing? A virtual hearing extends the functions and service that would normally found in physical hearing rooms to remote participants around the world, allowing conference and hearings to continue uninterrupted by physical restrictions like social distance or other situations. Usually, virtual hearings have been used for case management conference, interlocutory hearings and submissions, and full merit hearings. A virtual hearing will typically use some combination of three different elements: video conferencing or telepresence solution, electronic preservation evidence, which allows for simultaneous display of documentary evidence to all participants, and real-time transcription. Video conferencing and telepresence element will usually consist of the following categories of solutions: IP-based solutions, which usually utilizes specific hardware, which is typically found in large firms and hearing centers. And another one is cloud-based solutions. These are the technological media that we have frequently used these days, such as Zoom, WebEx, Teams, BlueJeans, Skype, among others, that allow for easier access for individual participants. About electronic presentation of evidence, I think it is one of the most useful tools for arbitrators and parties, because the system allows for the simultaneous display of evidence to all participants in the proceeding regardless of location, ensures that everyone is literally on the same page, ensures that witnesses and arbitrators are able to see evidence at counsel's direction, and also can be managed in certain situations by the parties themselves. For example, when dealing with a complex exhibit or evidence require expertise to navigate. And our last element is the remote transcription, which guaranteed that ensures access to a live transcript regardless of location. Remote access to transcription systems allow parties and arbitration to keep track of proceedings just like they were all in the same room. Allows for annotation and notes just like transcription systems in physical hearings. At the moment, these are some of notes about digital contribution using international commercial arbitration that I can mention. So, according with the 2018 Queen Mary and White and Case International Arbitration Survey, arbitration is the preferred ADR in the world for solve cross-border conflicts. And 51% of the respondents stated that prefer arbitration with another ADR, usually mediation. So in the Asia-Pacific region, Singapore and Hong Kong SAR are the third and fourth most preferred arbitration seats and institutions worldwide. And the question is, why is the success of these two jurisdictions? That's why we are going to talk some things about Singapore and Hong Kong. One of the aims of this paper is to conduct a comparative research of international commercial arbitration systems in Colombia, Hong Kong, SAR, and Singapore. According to the above, I decided to analyze these four criteria: the impact of the UNCITRAL Model Law, the corruption index, the legal regulatory of the third-party funding, and the most important institution in each jurisdiction. About the impact of the UNCITRAL Model Law, in Hong Kong, the entire text of the model law is included in the arbitration order. The arbitration ordinance applies for domestic and international arbitration. In Singapore, the International Arbitration Act includes the text of the model law, but excluded Chapter 8, which refers to the recognition and enforcement of arbitral offers, and does not apply amendments to the 2006 UNCITRAL Model Law. For domestic arbitration, Singapore issued the Arbitration Act, this Chapter 10 in 2002. And finally, in Colombia, we have the law 1563, of 2012, is based on the model law, but does not include paragraph B and C of the Article 1. In the jurisdictions of Hong Kong and Singapore, the UNCITRAL Model Law has the force of law. It's not the same case in Colombia. Another aspect that I looked at was the corruption index according to Transparency International 2019 report. As you can see in the slide, our two ASEAN Pacific jurisdictions are in the top 4, Singapore, and top 16, Hong Kong. In the Latin American case, Uruguay and Chile are the countries with the least corruption problems. Chile is currently one of the states most committed to international commercial arbitration in Latin America. Regarding third-party financing, the jurisdictions of Hong Kong and Singapore, after several public consultations, have issued laws that regulate third-party financing in the arbitration process. As in the code of practice, which strengthens the jurisdiction commitment to arbitration and place them at the global forefront of the matter. Both jurisdictions spent a period of testing these rules and they reviewed in 2021 the results of the implementation of these legal norms. In the Colombian case, there is not regulation in this regard that pose a possible threat to the impartiality and integrity of the arbitration process, given that in Latin America there are companies involved in this work. And finally, I examined the most important international commercial arbitration institutions in each jurisdiction. Singapore International Arbitration Center is the most preferred arbitration institution in the Asia-Pacific area and the third in the world. This institution offers to parties a choice of arbitration, mediation, arbitration procedure, and has the support of the Singapore International Mediation Center. The Hong Kong International Center is the second most preferred institution in the ASEAN Pacific region and the fourth in the world. In the case of Colombia, the Center of Arbitration and Reconciliation at the Bogota Chamber of Commerce represents an increase in the use of commercial arbitration process by transnational companies over the last 5 years. You can see the slide. Now we will come back to our virtual arbitration process. What's happening in Colombia? In Colombia, the law 1563 of 2012 states in the Article 23 the use of electronic media. In the arbitration process, electronic media may be used in all proceedings and in particular to carry out all communications, both from the court with the parties and with the third parties, for the notification of orders, the presentation of memorials, and the execution of hearings, as well as for saving their version and their subsequent consultation. Due to the pandemic, national courts in Colombia had to close and cannot serve the public. Quite the contrary, with respect to the arbitral tribunals, which have not stopped their activities, even in quarantine, because their procedure can be 100% virtual. Finally, I would like to point out some recommendations. Take notice of our virtual hearings, like agree the protocol, consider if the hearing requires a moderator, it's very important. Never share the links to the session publicly. Always use a session password. All the participants must be registered, and don't allow participants to join before the host. Make use the sense logout feature. Ensure the moderator or host has control of audio-video devices. Only permit those who need to be present to join in the session. All the other can view a private live stream. Okay, thank you very much. Balcho Spasiba, Sabinimani. Just luce para proceed.